Assalamualaikum warahmatullahi wabarakatuh. Hi guys, welcome back to my YouTube channel. Thank you for clicking this video. Before that, let me introduce myself. My name is Qintara Auliya Faradisa with student ID number 098 from Law and Business Ethics Class C. In this video, I will discuss about the role of engagement and agreement law along with an example of a case study that I took, namely at PT Bali Radiance, as requirement to meet the final examination with my teaching lecturer, Mrs. Novidiana Badrutamami. Have a good time to watching. Human interests in society are so broad, ranging from personal interest, social interest, to even the interests of the state. Therefore, we need a law that aims to regulate various human interests in the context of social life in society. In a legal context, the terms engagement and agreement have a very close relationship. In here, we will discuss the meaning of engagement and agreement and also relate case studies. Now friend, do you know the meaning and the difference of agreement, engagement? If not, I will help to explain. The law of engagement. An engagement is a legal relationship between two people or two parties based on which one party has the right to demand something from the other party and the other party is obligated to fulfill that demand. The party who has the right to sue for something is called a creditor, while the party who is obligated to meet the demands is called a debtor. Something that is demanded is called an achievement, and the violation is called a default. Engagement serves include treaties and law. Types of engagement. According to Sugiyarti 2016, there are several types of engagement. Namely, 1. Conditional engagement is an engagement that depends on an event that will come and may not occur. This conditional bond is divided into two types, namely conditional thought and conditional faith. 2. Timely engagement. This is an engagement that only occurs during the time that has become a specific agreement. 3. Alternative engagement. This alternative engagement uses other alternatives to solve the problem. 4. Liability engagement is an engagement in which each individual bears every consequence even though the individual didn't make a mistake or was not responsible. 5. An engagement which can be divided and cannot be divided. 6. An engagement with the threat of punishment is an agreement accompanied by a legal threat that guarantees the executor if the debtor does not fulfill his or her performance. Default or one prestasi. There are 4 consequences that can occur if one of the parties performs an achievement, namely 1. Paying losses suffered by other parties in the form of compensation. 2. Cancellation of the agreement. 3. Transfer of risk. 4. Pay the court fee if it comes to the judge's case. Seeking acknowledgement of negligence or wanting achievement is not easy. So, if the person concerned denies that he has committed an achievement, it can be proven in front of the court. The law of agreement. For business people, a letter of agreement may not be strict, because in the agreement letter, there are rules regarding the right and obligation of each party as well as things that the parties involved in the agreement letter shall not do. So, what is the agreement? An agreement is an act by which one or more people bind themselves to one person. Agreement is a legal act. This legal action gives rise to a legal relationship, so it can be said that the agreement is the source of the engagement. Types of agreement. If seen from the kinds of things that were promised, the agreement is divided into three. 1. An agreement to give something. 2. Agreement to do something. And 3. Agreement not to do something. Terms of validity of the agreement. In order for an agreement to be valid and binding on the parties, the agreement must meet four conditions, namely 1. The agreement of the parties on the things that were agreed upon. 2. The authority of the parties to enter into an agreement. 3. The existence of the object of the agreement, both in the form of goods and services. 4. True causes. Term 1 and 2 are also called subjective conditions. If the first and second condition can be fulfilled, then the second agreement is considered null and void. While the third and fourth terms are called objective conditions. Whereas if the third and fourth elements are not fulfilled, the contract is null and void. In the agreement, there must be an agreement between the two parties, which is known as the principle of consensualism. Because with an agreement, the agreement has been deemed valid by both parties regarding the matters that were agreed upon. Act against the law. Action against the law is a civil suit that can be filed in court by parties who feel aggrieved. Types of act against the law are divided into 5, namely 1. Action contrary to the right of the others. 2. Action contrary to legal obligation for themselves. 3. Action contrary to decency. 4. Action contrary to caution. The elements of act against the law. 1. An action by the defendant against the law. 2. There's an error. 3. There's a loss. 4. The existence of a causal relationship between the action committed and the consequences faced. Case study example. There are so many cases related to illegal act in court. In the following, I give an example of a case study related to the agreement and the consideration used by the judge. One of which is PT Bali Radiance. PT Bali Radiance is one of the large car rental companies in Badung Regency. Bali Radiance Transport is a transportation business formed by Irai Putra Sudanta and has become a division of a leading company, namely PT Bali Radiance International. This company is owned by the family of Rai itself and was founded in 1996, which is located at Jalan Basangkasa number 1009 Legian North Kuta. PT Bali Radiance has at least 107 vehicles that are ready to be rent out. Leasing starts with making a car rental agreement. To rent a car at PT Bali Radiance, the lessee must agree to the agreement made by PT Bali Radiance, where the agreement regulates terms such as the rental period, terms as a tenant, right, and obligation as a tenant. In the car rental agreement at PT Bali Radiance still often default on both intentional and unintentional. Default occurs when in an agreement one of the parties doesn't fulfill its obligation. Therefore, the tenant is obligated to be responsible for all defaults made. As for default, they are often done by the tenant at PT Bali Radiance is a delay in returning the car and damage to the rent car due to negligence of the tenant. Settlement of default can be done through two settlement channels, namely settlement through litigation in court and non-litigation outside court. For defaults that occur at PT Bali Radiance is resolved through non-litigation channels, namely negotiation and mediation, where the tenant compensates for the losses he has committed. Other defaults they are classified as separate, namely mortgaging the car rent by the lessee to a third party, will be resolved through litigation or court. As for the advice that I can give, both the tenant and the party renting or rent the car must be able to understand and carry out the entire contents of the car rental agreements as agreed by both parties, and if a default occurs, it can be resolved in accordance with applicable law. The conclusion. In principle, an engagement is a legal relationship between two parties when one party has the right to demand something from the other party and the other is obligated to fulfill the demands. Whereas an agreement is an event in which someone promises to another person or where two parties promise each other to carry out something. Departing from the above definition, it can be concluded that an agreement will create an engagement. Okay, this is the result of my presentation regarding the role of the law of engagement and agreement. More or less, I'm apologize. Hope it's useful. Thank you for watching this video until the end. Wassalamualaikum warahmatullahi wabarakatuh. See bye bye.